exercised her right to ask for review of the defendant's decision to terminate her employment under the employment and applied for review of the said decision via letters dated 26/11/2021 and 14/12/2021 and received no response from the defendant. Following the lack of response from the defendant, she approached the law firm of ASR2 to make further appeal to the defendant for review of termination of her employment, which termination the defendant justified in the letter of reply. And upon the termination of her employment by the defendant, the claimant was offered employment by Globus Bank Limited as an officer, but was forced to resign because of the reasons for termination of her employment by the defendant when Globus Bank Limited required a recommendation from the defendant. Her reputation as a banker has been ruined by the defendant's wrongful termination of her, particularly the reasons adduced by the defendant in the said letter of termination. The reasons the defendant adduced on the letter of termination are not established against the defendant by any shred of evidence. She was punished double by the defendant contrary to the conditions of service. Let me briefly state the case of the defendant. The defendant stated that prior to the 16th October 2021, on the 23rd day of July 2021, the Internal Control and Compliance Department of the bank received an electronic mail from an officer in charge of the defendant's Rivers and Bayelsa States offices requesting an investigation into a reported case of fraud in the disbursement of salary plus loan at its Yenagoa Junction branch. On the 2nd day of August 2021, the defendant received another report from one of its customers, one Raymond P. Raymond Hearing, and two other staff of the Yenagoa Nixon Junction branch demanded a 50% kickback on a yet-to-be disbursed loan of $1,900,000 only. Upon receipt of the reports and in line with the internal process, the claimant and three other staff indicted in the report were engaged by an officer of the defendant's Internal Control Department on the roles each of them played in the alleged fraud. Based on the responses from the claimant and the three other staff, the defendant petitioned the police on the alleged fraud committed by fraudster, one Mr. Esekumo Perekebino and his accomplice. Can you hear me?
Yes, my lord. Hey, my lord.
All right. The claimant responded to further written queries raised by the Internal Control Officer in respect of the fraud allegations via her email of 27 August 2021. And upon receipt of the claimant's response, the defendant, through its group internal audit and internal control department, commenced investigation into the allegation. And upon conclusion of the investigation, the GI department, the defendant produced its report dated 13 September 2021, indicting the claimant and three other staff of the defendant at its branch office at Nixon Junction, Yenagoa, for various acts of misconduct whereupon the claimant and other indicted staff were invited to attend the disciplinary committee to answer to the allegations and opportunity to state their case. A notice dated 28 September 2021 was sent via email to the claimant and the three other staff to attend the defendant's regional disciplinary committee in Port Harcourt on the 29th day of September 2021. The claimant, as well as the three other staff, attended the disciplinary committee meeting as scheduled and presented their case to the disciplinary committee, whereupon the disciplinary committee, upon consideration of the cases made out by the claimant and other staff, made its finding and recommendation to the defendant's management. And it was based on the disciplinary committee's review of the case made out by the claimant and two other staff that the defendant placed the claimant and the other three staff on suspension without pay for a period of 1 month for various infractions of its process as established during the investigation. The claimant's suspension was also to enable her recover the monies lost during the period of suspension, which commenced on the 16th day of October 2021. The defendant stated further that the term of suspension notice of 15th October 2021 is that the suspension was to recover the lost funds, but the claimant failed to make the necessary recoveries at the end of the suspension period, and the defendant therefore terminated her appointment with effect from the 20th day of November 2020. Officers, which include responsibility of verifying and validating all information and documentation provided by customers, who, including Mr. Perekebin, who is not a staff of the defendant and does not owe the defendant any such obligation. The account opening was, however, not completed, as the claimant and the other officers had failed, refused, or neglected to carry out their primary function of ensuring that documentation presented to the defendant were genuine. The claimant and three other staff failed to verify The defendant stated further that based on the report of its investigation, it was only the claimant that breached this particular policy when she notified the alleged fraudster, Mr. Perekevina, on how to circumvent the defendant's system and process which singular act enabled the alleged fraudster to succeed in his ploy to defraud the defendant. The claimant only notified the defendant that the salary of the Udeme Sunday was paid from the account of Mr. Parikevina in July 2021, after the loan to Sunday Udeme had been disbursed. The claimant is not entitled to any terminal benefit as shown on page 5, clause F of the 2015 disciplinary process and sanction grid document. Each of the officers who actively participated in the opening of the alleged fraudulent accounts was punished in accordance with the sanction grid for their role in the scheme as identified by the defendant during its investigation. The claimant's failure to alert the defendant of the payment of salaries from a personal account of Mr. Perekebina to that of Sunday Udome's account, which succeeded in obtaining the loan, played a significant role in the success of the fraud over and above any of the staff, and the said action also revealed that the claimant as an unfaithful and disloyal staff to the defendant. Now, on the 28th day of July 2021, it apprehended 3 of the suspected fraudulent loan beneficiaries at its branch office in Yenagua and handed them over to the police. The defendant's petition to the police was made by its regional internal audit officer at the police station. It was based on the statement of the 3 suspects and the defendant to the police that the fraudster, Mr. Perekebina, was subsequently arrested. The defendant never instigated the police to arrest the claimant at any time whatsoever, and the arrest of the claimant was not at the instance of the defendant, but as a result of the allegations leveled against the defendant. Counsel for the claimant nominated a sole issue for the determination of this suit, to wit, whether the claimant proved breach of contract of employment between the defendant and the claimant by the defendant so as to be entitled to relief thought, while counsel for the defendant nominated a sole issue for determination, that is, whether the claimant has successfully proved her case to be entitled to the relief thoughts. Issues nominated by the parties are same, though differently worded, and I will consolidate and adopt the 2 issues for determination in this suit. I will skip your legal submission and I will go to the decision part. You know what you submitted, so I will skip it. I have carefully gone through the pleadings, the evidence, and the legal submission of parties in respect of their respective case. To start with, the claimant claimed to be the employee of the defendant, and her employment with the defendant was confirmed on the 7th day of August 2013. The claimant tendered Exhibit CW001 and CW002 in establishing her relationship with the defendant. The defendant, in paragraph 2 of its statement of defense, admitted its employment relationship with the claimant. Thus, admitted facts goes to no issue. In legal proceedings, a party's admission serves as the most compelling evidence, relieving the opposing party from the burden of proof regarding the admitted fact. In civil cases, such admissions are considered evidence against the admitting party, unless valid explanations are provided to the court. If a party acknowledges a fact in their legal pleadings, they are bound by this admission and cannot later dispute it. Consequently, a court is permitted to render judgment based on this relevant admission. See the cases of Salawu against Yusuf, Hussein against Daud, and Ogwanu against Chibuka. The claims of the claimant, as they can be gleaned from the reliefs and the claimant's pleadings before this court, revolve around 3 facets. To which the defendant did not follow the laid down disciplinary requirements and procedure when the defendant suspended the claimant. Another one denies the salary and terminated the contract of employment of the claimant on the 20th day of November 2021. Under the suspension, denial of salary and termination of the claimant's employment in one breath without following the laid down disciplinary requirements and procedure constitutes a breach of contract of employment. And lastly, that the claimant is entitled to earn salaries during the period of suspension from duty and terminal benefits under the employment after the termination of employment with the defendant. Counsel for the defendant argued that the claimant did not present before this court the specific terms of the contract of employment, which shows the proper procedure and process which the defendant is expected to follow in suspending the claimant or terminating her employment, or which the claimant alleges that the defendant breached in each of these claims. Although the claimant tendered a letter of appointment, Exhibit CW001 in evidence, as well as the defendant's disparate procedure and sanctions grid and human resource manual as Exhibit CW and CW 013 respectively, the claimant did not point to the court to any of the portion of exhibits relevant to the claimant's case, and which portion of the said exhibits show the disciplinary requirement and procedure which the defendant ought to have followed. The Supreme Court, in the case of IBA against Shell Petroleum Development Company Nigeria Limited, held, and I quote, "It is the law that when an employee complains that his employment has been wrongfully terminated, he has the onus of placing before the court the terms of contract of employment before proceeding to prove the manner the said terms were breached by the employer. It is not the duty of an employer to who is a defendant brought by an employee prove any of such breach as laid down by this court in many cases, particularly Amadu against Amodi at Agbaje's JSC," unquote. In this instant suit, the claimant pleaded Exhibit CW001, CW013A, and CW012A, which are letter of appointment, human resource policy manual, and FCMB disciplinary process and sanctions, respectively. I have cautiously gone through the statement of facts filed on the 24th day of October 2022. I suppose the claimant pleaded the manner in Exhibit CW013A and CW012A were allegedly breached by the defendant, though the court must determine the correctness or propriety of the assertion of a claim. For ease of reference, I hereinonder reproduce paragraphs 28, 36, 37, and 38 of the statement of facts. Given the foregoing, it is due that the claimant has sufficiently demonstrated how the defendant allegedly breached its conditions of service, and I so hold. The claimant pleaded that she received a notice from the defendant on the 16th day of October 2021, asking her to proceed on 1 month suspension from duty without pay on allegations of failure to confirm the employment status of some persons who were granted loan by the bank and negligence of duty causing significant loss to the defendant. She proceeded on the 1 month suspension without pay, and upon return on the 20th day of November 2021, the claimant received another letter terminating her appointment with the defendant on the same date, alleging the same reasons as the suspension. The claimant tendered Exhibit CW009 and CW010. The event that led to the suspension and subsequent termination of the employment of the claimant is that one Mr. Perekebina, the client of the defendant, introduced SPL to other persons who were alleged to be staff of the Southern Ijo Rural Development Authority, Bayelsa State, and caused to be processed relevant account opening documents for the grant of loan facility through the assistance of a team of officers of the defendant. The claimant carried out the processing of the loan facility accounts of the alleged staff of Southern Ijo Rural Development Authority, Bayelsa State, introduced the defendant through Mr. Perekebina in company of Onyegule Ndubuisi Johnson and Ruth Oputa, and account officers of the defendant, for the said exercise. Completion of the account opening exercise, some of the alleged staff of the Southern Ijo Rural Development Authority Bayelsa State were granted loan to the tune of 4,988,000 naira as SPL facility. The defendant, in responding to the claim of the claimant, stated that on the 23rd day of July 2020, the Internal Control and Compliance Department of the defendant received an electronic mail from the officer in charge of the defendant, Rivers and Bayelsa State offices, requesting an investigation into the purported case of fraud, a disbursement of salary plus loan at Siena Gua, Nickton Road Junction branch. On the 2nd day of August 2021, the defendant received another report from one of its customers, Raymond Pili, alleging that the claimant herein and 2 other staff of the Enagua Nickton Junction branch demanded a 30% kickback on a yet to be disbursed loan of 1,900,000,000 only. Upon receipt of the reports and in line with the defendant's internal process, the claimant and 2 other staff indicted in the report were engaged by an officer in the Internal Control Department on the roles each of them played in the alleged fraud. Based on the response from the claimant and 3 other staff, the defendant petitioned the police on the alleged fraud committed against it by the alleged fraudster Perikebina and his accomplices. The police arrested the said Mr. Perikebina, who made statement to the police indicting the claimant. Based on the statement made by Mr. Perikebina to the police, the defendant's internal control officer further engaged the claimant in August 27, 2021. The claimant responded further. The claimant responded further. The written queries raised by the internal control officer in respect of the fraud allegation via her email of 27 August 2021. Upon receipt of the claimant response, the defendant, through its Group Internal Audit and Internal Control Department, commenced investigation into the allegation. And upon conclusion of the investigation, the GIA department of the defendant produced its report dated 13 September 2021, indicting the claimant and 3 other staff of the defendant at its Nicton Junction, Yenagua branch for various acts of misconduct, whereupon the claimant and the other indicted staff were invited to attend a disciplinary committee to answer to the allegations and have an opportunity to state their case. A notice dated 28 September 2021 was sent via email to the claimant and 3 other staff to attend the Defendant Regional Disciplinary Committee in Port Harcourt on 29 September 2021. The claimant and the 3 other staff attended the disciplinary committee meeting as scheduled, and they presented their cases to the disciplinary committee. Upon the disciplinary committee for consideration of the cases made out by the claimant and other staff, made its finding and recommendation to the defendant's management that it was based on disciplinary committee's review of cases made by the claimant and 3 other staff that the defendant placed the claimant and 3 other staff on suspension without pay for 1 month for the infraction of its process as established during the investigation. But the claimant's suspension was also to recover the monies lost during the period of suspension, which commenced on the 16th day of 2021. The defendant tenders exhibit DW002, DW003, and DW011. Given the facts and evidence highlighted above, it can be deduced from the foregoing that Mr. Perikebina, a client of the defendant, introduced the defendant loans facility known as Salary Plus Loan to some of his friends, who are allegedly staff of Southern Ijo Rural Development Authority by Bayelsa State. As part of the condition for our loan facility, the applicants or beneficiaries must have their salary account domiciled with the defendant, and the defendant must have received the salary of the applicants or beneficiaries in the account domiciled with them to ensure or ascertain that the applicants or beneficiaries are employees of the employer or beneficiaries claimed to be. Now, the claimant and her team opened the accounts for the applicants, which Mr. Perikebina introduced to the defendant. After the defendant pleaded and laid evidence to state that the claimant admitted that she noticed that the salary of one of the alleged impostors and loan beneficiaries, Udeme Sunday, was paid from the account of the said Mr. Perikebina a few times before the disbursement of the loan, rather than from the account of the Southern Ijo Rural Development Authority. The claimant, rather than not to notify the defendant, the claimant chose to notify the said Mr. Perikebina that the payment of salaries from personal account was a red flag for the defendant, and no loans will be dispersed to such customers if the monies were not paid from the Southern Ijo local government account. It was the claimant prompting of the said Mr. Perikebina that informed his allegedly opened an account in another bank in the name of Southern Ijo local government area, from which the salaries of the alleged importers were subsequently paid. See Exhibit DW003, DW006, DW004, which are very important here. One of the beneficiaries of the defendant's Salary Plus loan, named Udeme Sunday, opened his classic current salary account with the defendant on 23rd February 2021. See Exhibit DW006. On the 4th day of March 2021, reported salaries of December 2020, January 2021, and February 2021 of Udeme entered the salary account of Udeme Sunday domicile with the defendant from Mr. Perikebina, who brought Udeme Sunday to the defendant or introduced the defendant's Salary Plus loan to Udeme Sunday. See Exhibit DW004 and DW005. The claimant admitted in paragraphs 3 and 4 of Exhibit DW003 that the claimant was aware that the purported salary of December, January, and February 2021 of Udome Sunday were paid by Mr. Perekebin from his account instead of Southern Ijo Rural Development Authority, which is the purported employer of Udome Sunday, and informed Mr. Perekebin and Udome Sunday about the source of salary of Udome Sunday. The claimant found it inappropriate to inform Mr. Perekebin and Udome Sunday about the source of salary of Udome Sunday, but the claimant kept the secret away from her employer and is obligated to inform or bring to the notice of her employer any information the claimant came across in the performance of her duty to the Sam Erugo, the author of Introduction to Nigerian Labor Law, second edition, published in 2019 on page 124, noted that employees should disclose relevant and necessary information to their employers. This obligation pertains to the provision of information that affect the employer's business operations and appears to derive from fiduciary relationship rather than from contractual agreements. Employees are expected to inform management of any knowledge they possess regarding dishonesty among colleagues, particularly if they occupy a position of significant authority. The claimant sees the fact that the purported salary of December 2020, January 2021, and February 2021 of Udome Sunday were paid by Mr. Perekebin from his account instead of the Southern Ijo Rural Development Authority, which is the purported employer of Udome Sunday. The claimant, instead of disclosing this information to a defendant, so that the defendant could stop the salary plus loan process. But the claimant failed in her duty to be fidelicious and loyal to the defendant, but compromised her fidelity and loyalty with Mr. Perekebin to facilitate the approval of the salary plus loan in the sum of 4,988,000 by the defendant. In Exhibit DW008 and CW011A, the report noted that, and I quote, "We noted that the account officer, who has been in the system for 12 years, noticed that the suspect pays salary from his personal account. Yet she did not raise any suspicion, but rather advised the suspect to stop salaries from his personal account. We are inclined to believe that this action by the account officer was very suspicious for allowing the bank to disburse the loan despite the observed red flag," unquote. In the case of Abomeli against Nigerian Railway Corporation, the Court of Appeal held, and I quote, "It is an undeniable fact that the respondent lost money attributed to some unacceptable and untoward behavior of the appellant in his duties to his employer. He owed it as his duty to his employer to protect its property or use same in such a way that no preventable loss will occur. Of course, where he is steady and there is lack of diligence in his approach to his duty, or he is negligent, and the master by the same suffers loss, he is guilty of misconduct, to which appropriate disciplinary action can be taken. It is pertinent to state here that the doctrine of good faith in master and servant relationship is not based on dishonesty or on absolute loyalty. This connotes a concept that in the course of service being rendered by the servant, he must apply utmost diligence in his application to duty and work ethics that will put him in good state in the eyes of the employer. Thus, in merger against, it was held that a master is entitled to dismiss a servant whose conduct was simply incompatible with the faithful discharge of duty to his master. dishonest practices or criminal activities or acts and behavior that demonstrably portray an employee as an unreliable person are very strong reasons for an employer to dismiss an employee. The profuse nature of the affidavits of the applicant tend to cast the respondent in a monster role, thereby ignoring essentially the true issue is that the respondent lost confidence in him and is not ready to have him as in his employment, unquote. It is important to note that the claimant did not allege the denial of fair hearing, neither did he impeach the transparency of the investigation of the disciplinary committee of the defendant. Thus, there is no nicety in going to the proceeding of the disciplinary committee of the defendant. The claimant only complained about the sanction or decision of the defendant on suspension without pay, termination of employment of terminal benefit. Even if the claimant alleged denial of fair hearing, evidence abounds on the process that led to the decision of the disciplinary committee of the defendant. The basis of the decision of the defendant to suspend and subsequently terminate the employment of the claimant is XBDW 003, where the claimant admitted to having informed Mr. Perekevin and Udeme Sunday about the source of salary of Udeme Sunday. When an employer accuses an employee of, by way of a query and allows the employee to answer the said query, and the employee answers the query before the employer decides on the employment of the employee, that satisfies the requirement of fair hearing because he answered the respondent's queries before he was dismissed from his employment. See the case of Imonike against Unity Bank PLC, Rotsvival JSC. Also, the case against First Bank of Nigeria Limited, all citations provided and quoted. The claimant pleaded and laid evidence to state that the defendant hurriedly terminated the employment of the claimant on its own investigation without any reference to the police investigation and concluded the same to punish the claimant contrary to the terms of contract of employment and without waiting for the conclusion of the investigation. The report of the police investigation is XBCW 003, where the police investigated a case of conspiracy, forgery, impersonation, and fraud against each suspect, which included the claimant. XBCW 003 exculpated the claimant of the case of forgery and impersonation and fraud. However, XBCW 010A terminated the appointment of the claimant on the ground of gross misconduct. The defendant does not need the report of the police before proceeding to sanction the claimant for gross misconduct. It is a prerogative power of the defendant to do such. In the case of Arinze against First Bank of Nigeria Limited, the Supreme Court held, and I quote, "It is not necessary, it's a requirement under the Constitution that before an employer summarily dismisses its employee from service under common law, the employee must be tried before a court of law, where the accusation against the employee is for gross misconduct involving dishonest or bordering on criminality. To satisfy the rule of natural justice and fair hearing, a person likely to be affected directly by disciplinary proceeding must be given adequate notice of allegations against him to afford him an opportunity for representation in his defense. The complaint against him must not necessarily be drafted in the form of a formal charge. It is sufficient if the complaint as formulated conveys to him the nature of accusation against him. The views of Oputa and KSC Supra, which completely support and overlap the decision in use against Bank of Nigeria Supra, is to the effect that in cases of misconduct bordering on criminality, all that is required of an employer before summarily dismissing an employee is to give him fair hearing by confronting him with the accusation made against him and requiring him to defend himself. Unquote. As I earlier noted, the fulcrum of the decision of the defendant to terminate the appointment of the claimant with the defendant is XBDW 003, where the claimant admitted to have informed Perekebina and Sunday Ideme about the source of salary. Thus, failure of the defendant to wait for the report in XBCW 003 cannot invalidate the decision of the defendant on the fate of the employment of the claimant with the defendant, and I so hold. The contestation of the claimant is that the defendant, contrary to the conditions of service of the defendant, by suspending her for a month without pay, and thereafter terminating her appointment with the defendant, Page 3, paragraph D of Exhibit DW009 and page 26 of Exhibit DW001. Exhibit DW009, suspension can be issued where staff is suspected of serious misconduct and his presence in the workplace is considered undesirable or may impede the flow of intervention. The staff is then placed on suspension until investigation has been concluded. Again, paragraph F of Exhibit DW009 provides that all suspension shall be on hard payment unless otherwise provided in the suspension letter. In this instance, the defendant stated that the claimant as well as 3 other staff attended the disciplinary committee meeting on the 29th day of September 2021 and presented their case to the disciplinary committee, whereupon the disciplinary committee, upon consideration of the cases made out by the claimant and other staff, made its findings based on the disciplinary committee's review of the cases made out by the claimant and 3 other staff that the defendant placed the claimant and the 3 other staff on suspension without pay for a period of 1 month for various infractions of its process as established during the investigation. But the claimant's suspension was also to enable her to regain its lost during the period of the suspension, which commenced on the 16th day of October 2020. From the gamut of evidence before me, the suspension of the claimant was not subject to verified investigation by the defendant. As at the time the claimant was suspended, the defendant disciplinary committee had concluded its investigation and recommended the suspension of the claimant for recovery of the money. This is evident in Exhibit CW009. The suspension of the claimant from the employment of the defendant was not incongruous to page 3, paragraph D of Exhibit DW009 and page 26 of DW001. The defendant by Exhibit DW001 and DW009 has the power to suspend the claimant where the claimant is suspected of serious misconduct and her presence in the workplace is considered undesirable, and the claimant was directed to recover the money from the fraudsters. Exhibit DW009 also gives a caveat that suspension can be without pay if it is stated in the suspension letter. It is therefore the finding of this court that the suspension of the claimant and subsequent termination of the claimant from the employment of the defendant are not contrary to the provisions of Exhibit DW009 and DW001, and I so. Finally, on the issue of terminal benefits, the claimant asserted that she was not afforded any terminal benefit after the termination of her employment on the 20th day of November 2021, even though the claimant is entitled to such terminal benefit under the employment. However, the defendant stated that the claimant is not entitled to any terminal benefit as shown on page 5, clause F of 2015 disciplinary process and sanction grid document. The defendant, by its pleading and evidence, gave the termination of the claimant dismissal status. While dismissal is not synonymous with termination of employment, termination of employment is less in degree compared to dismissal. In the case of Pace Bank and PLC against Emeka, the Court of Appeal held, and I quote, the term of employment denotes the complete or absolute severance of an employer-employee relationship The term termination of employment denotes the complete or absolute severance of an employer-employee relationship. Contrariwise, the term dismissal denotes to release or discharge a person from employment. See Blackboard Dictionary, 9th edition, 2009, page 609, and page 537, respectively. In both cases, termination and dismissal, the employment of an employee brought to an abrupt end, albeit with varying consequences. While a contract of employment is terminated simpliciter, the employee is accorded the privilege of receiving the terminal benefits provided for under the terms of employment thereof. Characteristically, the right to terminate a contract of employment is mutually inclusive in that either party thereto may exercise it at will. Conversely, dismissal of an employee very often than not result in the loss of terminal benefits. What is more, it equally carries an unpleasant opprobrium to the unfortunate employee, unquote. In this event of the claimant, the defendant was terminated via Exhibit CW010A. Paragraph F of Exhibit DW009 provides that the employees whose contract of employment is terminated by the resignation of the staff or termination flowing from the foregoing, the claimant's employment with the defendant was terminated. Therefore, the claimant is entitled to a terminal benefit and so hold. On the whole, the claimant has succeeded in proving a claim of terminal benefits, but failed to prove other claims, and other claims accordingly are dismissed for lacking in merit. For avoidance of doubt, I hereby declare as contained in the relief sought by the claimant as follows. A declaration that the claimant is entitled to earn her terminal benefits under the employment after the termination of our employment with the defendant. An order compelling the defendant to forthwith pay all terminal benefits payable to the claimant as prescribed in the defendant's personal policy. All other claims, an order awarding 15% post-judgment interest in favor of the claimant against the defendant until the judgment sum is fully complete, and all other claims are hereby dismissed. All terms of this judgment are to be complied with within 30 days from today without prejudice to the right of appeal by parties, and judgment is hereby entered accordingly. Yes. Thank you so much, Mr. Sepeti.
Lord, we are grateful for the evidence we judgment to give us.
Thank you. Yes, the other matter.